Assets of community value are not a finite or fixed group, okay? What we're talking about is land or buildings having social interest, social well-being, having some form of public service benefit, sport, recreation and cultural benefit, community benefit, economic use, provided there is some social benefit sitting alongside it. So, what we have to do is look at current primary use, recent past use, or use now or in the next 5 years in order to determine whether or not on application a building should be listed. If we have a look at the notes and look at issues that we need to consider relating to land or property when we're thinking about listing, we should think about current ownership of the land and whether or not there is anything on the title that affords protection. So again, when you're doing your investigative work, it is important to check the position with regard to title. The problem, however, with restrictive covenants, well, restrictive covenants are subject to Section 84 of the Law Property Act 1925, meaning that I can apply to vary, remove, or even cancel restrictive covenants on my title. Section 84 allows such an application in circumstances where the restrictive covenant doesn't generate any real benefit for the party or land that has the benefit of the covenant, or in circumstances where the nature of the land in the vicinity has altered such that the covenant no longer carries any merit or is required. So you've got to be careful with restrictive covenants in that a restrictive covenant could be a factor in determining that there's no need for an asset to be listed. But whenever you've got someone raising that argument, bear in mind Section 84 of the Law Property Act 1925 and the possibility that a restrictive covenant that is currently in place is removed on application to land tribunal.